It takes a second. Okay, I believe we are streaming now. Okay, we're live.
Okay.
All right. Ready to go, Senator Sears.
Okay. All right. Eric, do you want to, we're going to start with execution of powers of attorney, not execution.
Right.
Good. Thank you for that.
You're welcome. A power of attorney, the execution of a power of attorney, to be
Yes.
precise.
Yes. Thank you, Senator Sears. Yes. So just to refresh everybody's recollection, I believe we've looked at this language, or at least virtually identical language. I think it was Friday, but at any rate, it was late last week. And we had looked at it after the committee had passed S316, which had to do with the execution of wills. And that was, you recall, the procedure that wills generally required the notarization of the will in the presence of two witnesses, as well as the person, the testator, the person who's actually executing the will. So you passed S316 to provide an opportunity, a method for those wills to be executed. Sorry to keep bringing up that word again, Senator Sears.
Yeah.
but to be done remotely, if it's done consistently with the emergency rules for remote notarial acts that were passed by the Secretary of State's office last week. So that provision passed the Senate S316, and this is essentially this exact same process for two other types of legal document signings. And the two documents are the first one you're looking at right now, as Senator Sears mentioned, it has to do with powers of attorney. The second one we'll look at in a moment has to do with deeds regarding the sale of real property from one person to another. But it's the exact same process. And actually, you may notice that the language is very similar because the language also is quite close to the same language that you passed in S316 with respect to wills. So with that as background, and actually just a moment more background. So the whole idea here is the exact same goal that you had with respect to wills. If you look at the existing law, which is the non-underlined language in the document you have in front of you right now, version 2.1, lines 6 to 8, that's existing law. So under the existing way that a power of attorney has to be executed, has to be signed in by the principal. That's the person who's providing authority to someone to act on his or her behalf with the power of attorney, whether it be to sell real estate or to sell other property, make medical decisions, that sort of thing. The principal is the person who's permitting someone else to act on his or her behalf. So this power has to be signed by the principal in the presence of at least one witness and acknowledged before a notary public. So again, very similar to the concept that you saw with respect to wills. You have this physical presence requirement of both the witness and the notary right there with the person who's signing the power of attorney. So again, as I mentioned, very similar language. If you look at the proposed new subsection F, so if you scroll down a little bit, you'll see that it's should seem very familiar. It only is in effect during the period that the emergency rules that were adopted last Wednesday by the Secretary of State's Office for Remote Notarial Acts are in effect. So it's time limited and connected to the COVID-19 pandemic. And so it's only going to be while these emergency rules are in effect, which I should point out is for 180 days. That's in the rules themselves. That's how long they last. And then they expire unless they're renewed, which is certainly a possibility. But for that 180-day period, you'll see lines 12, again, very almost identical to what you saw in the Wills Act. The witness to the power of attorney is going to be considered to be in the presence of the principal. That's that person who's providing the authority, whether or not the witness is physically present with the principal or the notary. As long as the procedures that are required by the emergency rules are in effect. And you may recall that the main point there was a secure audio visual real-time connection. And that was defined in the rule. And as long as that procedure is followed, then the document is able to be executed remotely and through the secure audio visual transmission. And then you see the sentence in subdivision 2 there, which is the effect of this process, assuming that it's followed properly. And if that's the case, if the power of attorney is executed as the emergency rules require, then it's presumed valid going forward. And that's just puts the document in a position of, if someone were to challenge it legally later on, for example, to try and make an argument that, oh no, somehow this remote process was invalid for some reason. Well, if they could show that the rules were followed and complied with, then there's at least a presumption that the document is valid. Now, it's only a presumption, so if there is some evidence that the other party could bring forward to show that, well, in fact, there is some cause to believe that it was invalid, then they could do that, but at least provides a presumption, so some security for the parties that decide to do the document this way.
Are there any questions?
Yeah,
Yes.
Go ahead. Joe first, I think I heard Joe, and then Al.
yep. Eric.
And then Jeanette.
I'm
And then
reading,
Jeanette.
Eric, I'm reading this rule and it refers to the Secretary of State's emergency rule. I don't know, because I haven't read that rule, whether they have dealt with the possibility that the immediate declaration of emergency is terminated and then a couple of 3-4 months later is reinstated. Do we have to come back and do all this over again, or is this going to fall into the second declaration of emergency?
I think it may depend on timing. My reading of the rule is it's in effect for 180 days, the emergency rule. And so that if the second declaration were to happen within that 180-day period, then no, you wouldn't have to do anything again. But if it were to happen further along than that, then, well, two things would happen. First of all, the emergency rules would expire 6 months from now, regardless. So at that point in time, I think you're right, there's going to have to be a reevaluation on the part of the Secretary of State's office, because whether this current state of emergency is still in effect, or whether it's because a second one has to be declared, there would require some action on their part to reenact the rule.
Do you know whether the Secretary of State's rule expires at the termination of the current Declaration of Rights as well as 180 days away, or is it just limited to the 180 days?
I am 100% certain of that. I think it's 180 days, but I'd want to double check to be sure.
Okay, this is a common problem that we were dealing with on the Rules Committee because we're trying to figure out how to design a permanent rule that would enable us to come back and do exactly what we're doing now without having to actually reconstruct it again. So I'm just going to float this out there that you may want to double check on that and find out whether the Secretary of State's going to be consistent with his 180 days, or he's actually got languaged in such a way that it terminates immediately upon the declaration. This particular pandemic, I don't know if you were listening earlier today, but this particular pandemic has a possibility of coming back in a second wave. And we might have declared the current emergency over with before that second wave comes back. So I guess what I'm just trying to get out there is we make sure we dovetail everybody's attempts to make corrections under those circumstances in such a way that they're consistent and can come back automatically without having to reconstruct it.
Okay.
Yeah, that makes sense. I'll double check that issue.
Thank you.
Alice, did you have a comment? Jeanette.
Jeanette, yes. I was going to ask about the 180 days also. And we are, since GovOps was the one that gave them the ability to write rules around electronic signatures. We're going to actually hear from them about how they intend to deal with this second wave possibility.
Okay. Anyone else with questions on the power of attorney? I'm going to stop calling it execution.
This is Ben Detman. Thanks for the opportunity to share. I just would add that clarify that the rules do expire 180 days after they were filed. And I presume that the Secretary of State has the authority to revoke their own rules during the 180-day period. But they don't automatically expire when the state of emergency is dropped.
Yeah.
Well, I would ask then, Ben, why would they be extended past the declaration of emergency?
Well,
That's what we're going to try and find out.
It's probably
Okay.
a better question for Chris Winters. But I will say that I made that point because if you're right, and there's a period of time when we're not in a state of emergency, but the rules are still available, then the Secretary of State could extend them if the state of emergency was reinstated, for lack of a better term.
Yeah, I'm just asking it in reverse now. If the declaration of emergency were eliminated tomorrow, why would we have this in place for the next 179 days?
Right.
I wouldn't see a reason to do that.
Okay,
Okay,
I think Jeanette's got it.
Well, can we make sure we ask that question of Chris Winters or Jim Condos to make sure we get an answer?
We'll put it on our agenda for Friday on GovOps.
Okay, thank you. Anybody else on the power of attorney comment? Okay, Eric, do you want to go to the deed recording?
Yeah, sure. In some ways, I could just say ditto here because this is almost identical to what you just looked at, except that, as you say, Senator Sears, it has to do with deeds rather than powers of attorney. But same concept. You look at the existing language, and this is the version 3.1 of the amendment to the deed statute 27 VSA 341. And you'll see again that existing laws, lines 6 through 10, and that generally when a deed conveys real property from one person to another, the grantor, the person who transfers it, and the grantee, the person who receives it, has to be acknowledged. This is line 7 to 8, by the grantor before a notary public. So again, you've got this physical presence requirement that the notary public has to physically be there while the acknowledgement is made by the person who's transferring the land, the real property, I should say. The proposed language takes the exact same approach that you just looked at with powers of attorney, and basically to achieve the same goal, which is that this procedure that statutorily right now requires physical presence between the notary and the person, the grantor of the real property, as long as the rules, the emergency rules from the Secretary of State's office are complied with, then this procedure can be done remotely again, can be done with the secure audio-visual transmission, and that the effect of that, as I mentioned earlier, is that as long as they're executed in compliance with the emergency rules, then it's presumed that the deed is valid. So it provides that evidentiary support going forward, and that the parties can be confident that that the property can still be transferred, even though they aren't physically present with each other, as long as they comply with the rules that the Secretary of State's office issued. So again, the language is virtually identical. And excuse me, sorry about that.
It's all right.
Anyway, that must have been my buzzer to be finished because I'm about done anyway. So yeah, that's pretty much it. Again, nothing more to add that's really any different than what we just went through with respect to powers of attorney. Very, very similar concept and similar language as well.
Very exciting stuff.
Yes.
Any other comments from anybody on the committee? Questions, comments from folks that are listening in the profession?
You have Chris Mealy and Terry Cressones on the agenda.
I know, but
Okay.
I'm, yes,
Okay.
okay.
Just wanted to let you know.
If they want to speak, that's fine. We also have other people available too, so
My audio.
on the, yeah.
Alice? Can I ask a question, Dick?
Yes, please.
I'm just wondering, on some of the instructions for notaries that the Secretary of State sent out, he has one piece where it says, each remotely locate, no, wait a minute. That you must retain the notary must retain shall retain the audio visual recording of the meeting for at least 7 years. I don't see how that's going to happen. The notary public shall maintain the audio visual recording of the meeting for at least 7 years. That's on page 4 of something that guidance on emergency rules for notaries. It came from the Secretary of State. And I have to admit, that's quite a surprise, and I don't see how that's going to happen. Notaries aren't capable of doing that. So I don't know, that's something to check out.
Maybe Jeanette can check on that Friday.
I just made a note of that.
Okay, that'd be
What?
good.
Hi, this is Benj Detman in Middlebury. Thank you for giving me the opportunity to speak. I will say that the rules are helpful in that they will assist us in allowing contracts we already have with clients with contractual deadlines to fulfill those obligations and to allow some commerce to proceed. I'll say that I would say most practitioners are not a fan of the idea of having to record an audiovisual record of the notarial act and then retain that recording for 7 years. But that is the rule. I think it means that we'll use the rule more sparingly because it's going to be an onerous thing to achieve. I think Zoom itself actually is a secure portal that allows for recording. So that may be how some of us do it. I'll also add, though, that it's come to my attention that most professional liability insurance carriers do not insure professionals that are involved in that activity for that activity. It's an exception to coverage. So I think that means that we'll use this rule very sparingly. But again, we're a customer service industry that has clients with existing obligations, and we want to fulfill those obligations and serve our clients as best we can. So while I'm not super excited about the way this has come about, and especially about that part about the professional liability insurance that, of course, you can't do anything about, I will say we in the profession consider this vital because, again, we have clients with existing needs.
Thank you. Anyone else on either the power of attorney or the deeds? Eric, thanks so much for the work on this.
Sure. Just one quick question, Senator Sears.
Yep.
Do you ultimately want these folded into the S-114 that Bryn's working on, or?
Yes, I think
Yeah.
that was the general idea.
Okay.
Good.
Should we plan on that for the next version, maybe?
Yes, hopefully next Tuesday or Tuesday or Wednesday we'll meet, get permission to meet and make sure we have the permission to vote. And that will give you plenty of time to send out the draft copies of this to everyone.
Sounds great. Thank you.
Thank you, Eric.
You bet.
Anybody else with any comments on either the deeds or the power of attorney? Okay, Bryn, can we go back to the suspension of the statute of limitations and maybe hear from Chris Mealy first, since you already kind of went through them?
Dick, can we ask Eric? I think Eric has the
Yep.
the bill on the screen and it's blocking my ability to see everybody.
Yep. Peggy's probably doing that. Peggy, can you take that bill down?
Sure.
Yeah,
Thank you.
if
No,
I could just say to Peggy, when you put it up like that, I know it's to be helpful to the committee, but we're not able to scroll through it because it's controlled at your end. So it's easier if we put up our own version of it and
Yep.
we can toggle back and forth, because
That works.
otherwise, as Joe said, it closes out Zoom basically.
Yeah, that would be a lot easier for me also.
Okay.
The same thing happened when Mark Hughes was presenting his stuff.
Yeah.
If it was sent to us electronically ahead of time, we can all look at it.
Yeah.
Most of us have two devices.
Yeah, I think that is an easier way to do it, definitely. So I won't plan on sharing unless you guys let me know that you want me to.
Okay, thank you. Chris, you want to speak a little bit about why we need to do the suspension of statute of limitations?
Sure. Thanks for allowing me to speak. Chris Maley, I'm an attorney in Burlington, and I file lawsuits, and so I have the practical experience of what this statute could mean. In order to bring a claim, we need to do certain things out in the world. And so from a public safety perspective, doing our typical due diligence, meeting with witnesses, getting records, talking to experts, it's all pretty much jammed up at the moment. And so it would be hard for us to get our ducks in a row in order to be able to make allegations and say we have a good faith basis to do so in order for a complaint. And for me, filing a complaint means actually walking into Chittenden Superior Court and asking that I get a stamp on it and a docket number, and then more often than not, I'm getting a sheriff involved to serve a complaint. All of this is problematic in today's world. And so we're supportive of the language. And I had the benefit of hearing what Judge Grierson commented about, and I was already going to say that I thought that the second paragraph was unnecessary. Judge Tour entered an order on how to deal with her cases and extended some deadlines within the pending cases. So we're just talking about cases that have not yet been filed, and that the statute of limitations would bar people from access to the court during the time of the state of the emergency. And so we would like to have the statute as it's drafted. And then also we're fine with what Judge Grierson suggested by way of an addition, that sentence where he said this only applies to deadlines that would otherwise expire during the state of the emergency. So we're okay with that as well. When I say we, I mean the Vermont Association for Justice, which is about 190 trial lawyers. The other piece that I heard was that Senator Benning was talking about what happens if the emergency comes up, and this language says any state of emergency declared by the governor. So I think we're okay on that piece. If there was another one, but I looked to others for comment on that. But in the big picture sense, we're supportive of the language as edited by Judge Grierson. I can't hear.
Doing here. I get muted. I muted myself. Any other questions or comments on this particular suspension of statute of limitations?
Dick,
Yes, Phil.
I'm wondering on page 5, line 2, it says 160 days. Is that supposed to be 60?
Good question.
So that is, that's the provision that suspends the statutory timelines for court proceedings related to expungement and sealing petitions. And that was a part of the memo that came from Judge Grierson. The request from the judiciary was that those timelines not only be suspended for the duration of AO 49, but beyond it. And
But what is the logic of 160?
that I feel like would be better answered by Judge Grierson.
I'm wondering if it's not a typo because everything else is 60 days.
I'm sorry, it is a typo, but the request was 120 days. 120 days after AO 49 expires.
Okay, 120, I can see
Makes
there's
a
a
little more sense.
30-day.
Yep.
Yeah.
I'll make that change.
Okay, thank you for picking that up. Any other questions on any of the bill that we've been working on? We became so efficient, we've got extra time, which means we could always end early.
Oh, that would,
Oh,
This is
that would be
Carrie.
lovely.
All right. Peggy, thank you so much. And I realize we started kind of late, and I wanted to just take a moment with the committee on how, I mean, this is all new to me. I've never done anything like this. None of us have. So how, considering Mark Hughes's comment about voices being heard, how can people who would normally might be in the room, in a committee room, how can they be heard? Is there a way through, if they're watching it on YouTube, can they can't get in without putting, sending you a message, or what would be the process?
So I don't understand exactly how the YouTube thing works, but the way, and this has probably changed since we've had our committee meetings, because we haven't had any since last week, but my understanding was that anybody could call in. They just didn't have the ability to speak. But in our committee meetings, I just asked people if there was anybody out there that in the ether world that wanted to comment. But I guess if
Well, how would they?
have we limited that?
Well, they can't comment if they're not part of the Zoom code that we've established.
Yeah.
So,
Well, other people don't have the ability to do that, to call in and do that. It's only invited guests.
Yes.
Yes.
Yeah, the only people that get the Zoom information are the witnesses, attorneys, and anyone that a chair would specifically ask. The YouTube live stream is for the public.
That I think presents a real problem, because we often don't know who it is out there that's going to have something to comment. For example, when we were dealing with open meetings, there were a number of people who I wouldn't have thought of to specifically ask, but they ended up having some very insightful information for us. I don't know why people can't have the call-in number and just sit there and be quiet.
Terry,
about their
you wanted to comment? Terry Corsones wanted to comment?
Oh, hi, sorry, not on what Senator White just indicated, but I apologize. I didn't figure out the raise hand symbol soon enough. I'm just gonna, but I can wait until after Senator White's comment is.
Okay, fine.
I did want to speak to Jeanette's comment.
Yep, go ahead.
So
We're
I've
still
been,
live stream, by the way. Just let me know.
Yeah.
No,
okay.
I'm good. I want this
Yeah.
live stream.
Okay, I just want to make sure you guys know. Go ahead.
so I view this as analogous to what's happening in the State House. So in our committees, people don't have the ability to walk into the room and then request to speak. I mean, in an extraordinary situation, you let somebody speak, but if they're not on the witness list, they're there to observe, not to give public comment. So I view this as the same way. People can listen in, then they can contact their representatives, or they can contact the committee to be considered as a witness. But I don't think we should get into the business of allowing people to call in and say they want to speak, because that once you put that gate down, I do think we'll have a certain amount of chaos.
Can I comment on that?
Yep.
In our committee, I always ask when people are in the room, if we have some time and if there's an issue that they've specifically come for, I always ask if there's anybody else who would like to comment. And even if they're not on the witness list, if we have time and they have something different to say, I've always asked.
Well, I guess the best way to deal with that would be for people to email the host, in this case, Peggy or whatever, or if they have it, they could be heard at the next meeting.
And I think they can also, if someone, I mean, the agendas are posted. So if somebody's interested in being part of the meeting, they can email me and I can ask Senator Sears for permission. But
Okay.
I do agree with Senator Baruch. That is the intent of this. I can tell you it's tough enough, challenging. It's challenging enough managing these meetings just with you guys and the witnesses. If we had 20, 30 people calling in, and I don't know how many people would, but I did just think that, you know, it's challenging. And I think anyone can always ask for the information, and I can ask the chair and Senator Sears or Senator White, if there's anyone that you want to be included, you can ask your committee assistant to send them that information.
Yeah,
Thank
no,
you.
I agree with that. And I do know that we had sometimes 30 or 40 people on, and this was just call in. They couldn't have gotten on the audio. They were, even when we were on Zoom, they were just on the, I mean, they were not on the video, they were just on audio. And they were respectful and it worked fine, but I understand. I just feel bad that we can't have the ability then to ask other people who didn't necessarily ask to be on the witness list.
All right. Terry?
Right, thank you. Regarding the statute of limitations discussion, Chris had asked whether the VBA would have a position on the bill, and I just want to indicate we have a protocol for providing that, but given that the draft didn't come out until late morning, and now it sounds like some changes are being made, we can do that, but it wouldn't, it would be tomorrow afternoon, for example, and would that?
No, that's, I think we'd be voting next week, because I first need to get the Joint Rules Committee to agree to allow us to vote remotely. And secondly, I think the staff needs time to redraft, and I would think they would get that out to you by Monday. That's what I heard, Eric, and I think Bryn agreed that would work if we could get it out by Monday.
That would work for me. That would be no problem.
So
Okay.
we'll try to meet like next Wednesday or Thursday and do the vote, unless we hear that we're going back on Tuesday and they want the bill done, blah, blah, blah. That's the only thing that would get in the way.
Okay, well, we'll
There was
circulate.
some discussion this morning about going back into session next Tuesday.
Okay, well, I'll coordinate with Bryn, but we can use the language that's decided upon. It sounds like.
Yeah, the revised language that was suggested on that. Yeah.
Okay, great. So then we will provide input and thank you for your flexibility.
I've got somebody at the door.
Marley's needing a mute. Marley needs a mute button.
Marley needs a
Hopefully
mute
it's not a
button.
sheriff.
That doesn't work. That doesn't work when somebody's at the door. So I'll have to mute my. Are we all done?
I think we're done.
Yes,
We're done.
Yeah, have a great day. And
Okay,
we'll see you
bye.
tomorrow morning.
Take care.
at 10 o'clock. Bye now.
bye,
Thank you.
Bye, everybody.
bye.
Bye-bye.